Hi, everybody. I'm doing a little early morning reading because we had fun stuff going on last night, so didn't get to read last night. So, good morning. All right, we're picking up in part 3 of Ferens versus John Deere Company. All right, part 3. The quoted part from Van Doren reveals 3 independent reasons for our decision. First, section 1404A should not deprive parties of state law advantages that exist absent of diversity jurisdiction. Second, 1404A should not create or multiply opportunities for forum shopping. Third, the decision to transfer venue under 1404A should turn on considerations of convenience and the interest of justice, rather than on the possible prejudice resulting from a change of law. Although commentators have questioned whether the scant legislative history of 1404A compels reliance on these policies, see the note for choices of law as to transfer of venue, Yale Law Review Journal, 1965. We find it prudent to consider them in deciding whether the rule in Van Dusen applies to transfers initiated by plaintiffs in this case. We decide that, in addition to other considerations, these policies require a transferee's forum to apply the law of the transferor court, regardless of who initiates the transfer. A transfer under 1404A, in other words, does not change the law applicable in a diversity of jurisdiction case. Section 3A. This is a Justice Kennedy opinion, by the way. The policy that 1404A should not deprive parties of state law advantages, although perhaps discernible in the legislative history, has its real foundation in the Erie Doctrine from Erie versus Pennsylvania Railroad. Right? See Van Dusen, which cites Erie at page 637. The Erie rule remains a vital expression of the federal system and the concomitant integrity of the separate states. We explained Erie in Guarantee Trust Company v. York as follows, quote, in essence, the intent of the Erie Doctrine and decision was to ensure that in all cases where a federal court is exercising jurisdiction solely because of the diversity of citizenship of the parties, the outcome of the litigation in the federal court should be substantially the same, so far as legal rules determine the outcome of a litigation, as it would be if tried in any state court. The nub of the policy that underlies Erie is that for the same transaction, the accident of a suit by a non-resident litigant in a federal court instead of a state court a block away should not lead to substantially different results. If you're going to sue in a federal court in Cheyenne, Wyoming, or in a state court in Cheyenne, Wyoming, the fact you're suing in a federal court should not mean that the outcome of the case is different than it would be in the state court. And that's what they're going for, comedy between the states and the federal government. All right. In Hannah v. Plummer, we held that Congress has the power to prescribe procedural rules that differ from state law rules, even at the expense of altering the outcome of litigation. This does not involve a conflict. As in Van Dusen, our interpretation of 1404A is in full accord with the Erie decision. The Erie policy has a clear implication for Van Dusen. The existence of diversity jurisdiction gave the defendants the opportunity to make a motion to transfer venue under 1404A. And if the applicable law were to change after transfer, the plaintiff's venue privilege and resulting state law advantages could be defeated at the defendant's option. To allow the transfer and at the same time preserve the plaintiff's state law advantages, we held that the choice of law rules should not change following a transfer initiated by a defendant. All right, we got that. Transfers initiated by a plaintiff involve some different considerations, but lead to the same result. Applying the transferor law, of course, will not deprive the plaintiff of any state law advantages. A defendant, in one sense, will also lose no legal advantage if the transferor law controls after a transfer initiated by the plaintiffs. The same law, after all, would have been applied if the plaintiff had not made the motion. In another sense, however, a defendant may lose a non-legal advantage. Deere case, the present case, for example, John Deere, would lose whatever advantage inheres in not having to litigate in Pennsylvania, or put another way, in facing the Ferenses to litigate or forcing the Ferenses to litigate in Mississippi, or not at all. We nonetheless find the advantage the defendant loses is very slight. Okay, Kennedy. A plaintiff always can sue in a favorable state court or sue in diversity and not seek a transfer. By asking for the application of Mississippi statute of limitations following a transfer to Pennsylvania on grounds of convenience, the Ferens are seeking to deprive John Deere not only of the advantage of using against them the inconvenience of litigating in Mississippi. The text of 1404A may not say anything about choice of law, but we think it is not the purpose of this section to protect the party's ability to use inconvenience as a shield to discourage or hinder litigation otherwise proper. This section exists to eliminate inconvenience without altering permissible choices under venue statutes. This interpretation should come as a little surprise. In our previous case, we think that, quote, to construe 1404A this way merely carries out its design to protect litigants, witnesses, and the public against unnecessary inconvenience and unnecessary expenses, not to provide a shelter for proceedings in costly and inconvenient forums. Quoting from Continental Grain Company versus Barge FBL 585, which is a U.S. Supreme Court case from 1960. By creating an opportunity to have a venue transfer between courts in different states on the basis of convenience, an option that does not exist absent federal jurisdiction, Congress, with respect to diversity, retained the Erie policy while diminishing the incidence of the inconvenience. Applying the transferee law, by contrast, would undermine the Erie rule in a serious way. It would mean that initiating a transfer under 1404A changes the state law applicable to a diversity case. We have held that, in an isolated circumstance, that 1404A may preempt state law. See Stewart Organization Incorporated versus Rich Corporation in general. However, we have seen that 1404A as a housekeeping measure that should not alter the state law that governs the case under the Erie Doctrine, quoting from Van Dusen. Finding that a language of 1404A was plainly insufficient to work a change in an applicable state law through preemption. The Mississippi statute of limitations, which everyone agrees would have applied if the Ferens had not moved for a transfer, should continue to apply in this case. In any event, defendants in a position of John Deere would not fare much better if we required application of the transferee's law instead of the transferor's law. True, if the transferee's law were to apply, some plaintiffs would not sue the defendants for fear that they would have no choice but to litigate in an inconvenient forum state. But applying the transferee law would not discourage all plaintiffs from suing. Some plaintiffs would prefer to litigate in an inconvenient forum with a favorable law, and some would prefer that over litigating in a convenient forum with an unfavorable law, or maybe to not litigate at all. The Ferens, no doubt, would have abided by their initial choice of the district court in Mississippi had they known that the district court in Pennsylvania would have dismissed their action. If we were to rule for Deere in this case, we would have accomplished little more than discouraging the occasional motions by plaintiffs to transfer inconvenient cases. Other plaintiffs would sue in an inconvenient forum, with the exception of the defendants themselves would seek to transfer for a convenient forum, resulting in the application of the transferor law under Van Doren. In this case, for example, Deere might have moved to transfer it if the Ferens had not. Van Dusen has also sought to fashion a rule that would not create opportunities for forum shopping. Some commentators have seen this policy as the most important rationale behind Van Dusen, but few attempt to explain the harm of forum shopping when the plaintiff initiates the transfer. An opportunity for forum shopping exists when a party has a choice of the forums which will apply different laws. The Van Dusen policy against forum shopping simply requires us to interpret 1404A in a way that does not create an opportunity for obtaining a more favorable law by selecting a forum for the transfer of venue. In the Van Dusen case itself, this meant that we could not allow defendants to use a transfer to change the laws. No interpretation of 1404A, however, will create a comparable opportunity for forum shopping by a plaintiff, because even without 1404A, a plaintiff already has the option of shopping for a forum with the most favorable law. The Ferens, for example, have the opportunity for forum shopping in the state courts because both Mississippi and Pennsylvania courts had jurisdiction and because they each would have applied a different statute of limitations. Diversity jurisdiction did not eliminate these forum shopping opportunities. Instead, under Erie, the federal courts had to replicate them, according from Claxon. which says, whatever lack of uniformity Erie may produce between federal courts in different states is attributable to our federal system, which leaves to a state within the limits permitted by the Constitution the right to pursue local policies diverging from those of its neighbors. Applying the transferor law, would not give a plaintiff an opportunity to use a transfer to obtain a law that he could not obtain through his initial form selection. And if it does make a selection of the most favorable law more convenient, it does no more than recognize the forum shopping choice that already exists. This fact does not require us to apply the transferee law. Section 1404A, to reiterate, exists to make venue convenient and should not allow the defendant to use inconvenience to discourage plaintiffs from exercising the opportunities that they already have. Under the transferee law, by contrast, might create an opportunity for forum shopping in an indirect way. The advantage of Mississippi's personal injury lawyers that resulted from the state's then applicable 6-year statute of limitations has not escaped us. Mississippi's long limitation period no doubt drew plaintiffs to Mississippi. Although Sun Oil held the case that federal courts have little interest in a state's decision to create a long statute of limitations or apply the statute's limitations to claims governed by a foreign law, we should recognize the consequences of our interpretation of 1404A. Applying the transferee law to the extent that it discourages plaintiff-limited transfers might give the states incentives to enact similar laws to bring out-of-state businesses that would not be moved there at the insistence of the plaintiff. Section C. Section C. Van Dusen also made clear that the decision to transfer the venue under 1404A should turn on considerations of convenience rather than on the possibility of prejudice resulting from a change in the applicable law. We reasoned that, Van Dusen, the law changed following a transfer initiated by the defendant. A district court would, quote, at least be reluctant to grant transfers despite considerations of convenience, if to do so might conceivably prejudice the claim of a plaintiff, close quote. The court, to determine the prejudice, might have to make an elaborate survey of the law, including statutes of limitations, burden of proof, presumptions, and all this like. This would turn what is supposed to be a statute of convenience of the court, or for convenience of the court, into one expending extensive judicial time and resources. Because this difficult task is contrary to the purpose of the statute, in Van Dusen we made it unnecessary by ruling that a transfer of venue by the defendant does not result in a transfer of law, or a change of law, rather. The same policy requires an application of transferor law when the plaintiff initiates a transfer. If the law were to change following a transfer initiated by a plaintiff, a district court in a similar fashion could be at least reluctant to grant transfer that would prejudice the defendant. Hardship might occur because plaintiffs may find that as many opportunities to exploit the application of the transferor law if the transferor's law were to apply. Moreover, the plaintiff simply would not move to transfer unless the benefits of convenience outweigh the loss of favorable law. Some might think that a plaintiff should pay the price for choosing an inconvenient form by being put to a choice of law versus forum. But this assumes that 1404A is for the benefit only of the moving party. By the statute's own terms, it is not. Section 1404A also exists for the benefit of witnesses and the interest of justice, which must include the inconvenience of the forum or inconvenience of the court. Litigation in an inconvenient form does not harm a plaintiff alone. As Justice Jackson said, not this Justice Jackson, Justice Old School Jackson said, quote, administrative difficulties follow for courts when litigation is piled up in congested centers instead of being handled at its origin. Jury duty is a burden that ought not to be imposed upon the people of a community which has no relation to the litigation. In cases which touch on the affairs of many persons, there is reason for holding the trial in their view and reach rather than in remote parts of the country where they can learn of it by reports only. There is a local interest in having localized controversies decided at home. There is an appropriateness, too, of having the trial of a diversity case in a form that is at home with the state law that must govern the case, rather than having a court in some other form untangle problems in conflicts of laws and in law that is foreign to itself. In Gulf Oil Corp v. Gilbert, a 1947 case, the desire to take a punitive view of the plaintiff's action should not obscure the systemic cost of litigating in an inconvenient forum. My God. All right. D. This case involves some considerations to which perhaps we did not give sufficient attention in Van Dusen. Foresight and judicial economy now seem to favor the simple rule that the law does not change following a transfer of venue under 1404A. Affording transferors initiated by plaintiffs and different treatment from transfers initiated by defendants may seem quite workable in this case, but the simplicity is an illusion. If we were to hold that the transferee law applies following 14404A, motion by a plaintiff, cases such as this would not arise in the future. Although applying the transferee law no doubt would catch the Ferens by surprise, in the future no plaintiffs in their position would move for the change of venue. Other cases, however, would produce undesirable complications. The rule would leave unclear which law should apply when both a defendant and a plaintiff move for a transfer of venue, or when a court transfers venue on its own motion. The rule might also require variation in certain situations when the plaintiff, such as when the plaintiff moves for a transfer following the removal from a state court by the defendant, or when only one of several plaintiffs requests a transfer, or when circumstances change through no fault of the plaintiffs, making a once convenient forum inconvenient. True, we could then reserve any considerations of those questions for a later day, but we have a duty in deciding this case to consider whether our decisions will create litigation and uncertainty. On the basis of these considerations, we again conclude that transferor law should apply regardless of who makes a 14404A motion. Section 4. Some may object that a district court in Pennsylvania should not have to apply a Mississippi statute of limitations to a Pennsylvania cause of action. Yeah, people might. This point, although understandable, you damn right it is, should have little to do with the outcome of this case. Congress gave the Ferens the power to seek a transfer in 1404A, and our decision in Van Dusen already could require a district court in Pennsylvania to apply the Mississippi statute of limitations to Pennsylvania claims. Our rule may seem too generous because it allows the Ferens to have both their choice of law and their choice of forum, or even to reward the Ferens for conduct that seems manipulative. A little bit. We nonetheless don't give a fuck. See no alternative rule that would produce a more acceptable result. Deciding that transferee law should apply in effect would tell the Ferens that they should have continued to litigate their warranty action in Pennsylvania and their tort action in Mississippi. Some might find this preferable, but we do not. Thanks, Anthony Kennedy, you piece of poop. We have made it quite clear that, quote, to permit a situation in which two cases involving precisely the same issues are simultaneously pending in different district courts lead to the wastefulness of time, energy, and money that 1404A was actually designed to prevent, quoting from Continental Grain. For a substantive standpoint, two further objections give us pause, but do not persuade us to change our rule. First, one might ask why we require the Ferens to file in the District Court of Mississippi at all. That's a good question. Efficiency might seem to dictate a ruling allowing plaintiffs in the Ferens' position not to file an inconvenient form and then return to a convenient form through a transfer of venue, but instead simply to file the convenient form and ask for the law of the inconvenient form to apply. That would make logical sense. Although our rule may invoke certain formalities, one must remember that 1404A does not provide an automatic transfer of venue. The section instead permits a transfer of venue only when convenient and in the interest of justice. Plaintiffs in a position of the Ferens must go to a distinct forum because they have no guarantee until the court there examines the facts that they will actually get a transfer. No one has contested the justice of transferring this particular case, but the option remains open to defendants in future cases. Although a court cannot ignore the systemic cost of inconvenience, it may consider the course that the litigation already has taken in determining what the interest of justice will be. Second, one might contend because there is no per se rule requiring a court to apply either the transferor law or the transferee law will seem inappropriate in all circumstances. We should develop a more sophisticated federal choice of law rule for diversity actions that involve transfers. To a large extent, however, state conflicts of law rules already ensure that appropriate laws will apply to diversity cases. Federal law, as a general matter, does not interfere with these rules. See Sun Oil, U.S. 46. 727 through 729. In addition, even if more elaborate federal choice of law rules would not run afoul of Claxon and Erie, two previous decisions, we believe that applying the law of the transferor forum affects the appropriate balance between fairness and simplicity. For the foregoing reasons, we conclude that Mississippi's statute of limitations should govern Ferens' case and Ferens' action. We reverse and remand for proceedings consistent with our opinion. Well, there you go, folks. There's the upending of forum shopping to making it available to everybody throughout time immemorial and future. So, good luck with that. Have a good day.